Okay, on the record, in the matter of the people of the state of Michigan versus Dan Lee Darling, trial number 22-02645FY, council appearance.
Ryan Ring on behalf of the people. And thank you, Your Honor. Robert Palmer of the Public Defender's Office on behalf of Mr. Dan Darling, who appears today via.
Okay, today's the date that was set for a sentencing, and then there was a restitution hearing. My understanding is that there's now been a stipulation to the restitution amount. Is that correct?
That is correct, Your Honor. That's accurate, Judge.
Okay, and I have the amount here at $2,000.
That's correct, Judge. Just to be clear, it's $2,000 as to Mr. Pettit. There were two
Okay.
complaining witnesses in this matter. The other amount was already stipulated to as part at the time of the original.
That's the 2,675.
No, well, Judge, just to be clear, it was the 2,500 with regard to Miss Oxendale, the other complaining witness, was stipulated to at the time of the plea. 2,675 was what was originally being requested by Mr. Pettit. We've come to a stipulation as to that amount regarding Mr. Pettit being 2,000.
Gotcha. Let me see what's going on here. I have one victim, one of 2,675. So I don't need this.
That's correct, Judge. The 2,675 is going away, and it's just going to be 2,000.
Okay, I do see for Oxendale in the file for 2,500, and then for Anthony Pettit 2,000. That's accurate.
That is accurate, Judge.
Accurate, Judge.
Okay, very good. And that's your understanding as well, Mr. Darling?
Yes, Your Honor.
Okay, you can make allocation.
Thank you, Your Honor. The court should have received the PSI. It's a relatively straightforward and simple PSI. I'm asking the court follow that recommendation. As the PSI indicates, he is a moderate to low risk in terms of responsivity. The mains, my client is employed full-time. He is a contractor, as it's indicated on this PSI as well. Additionally, my client lives over in Mulliken, which is quite a drive west of here. He stays over in that area because it's close to work, and also because he's caring for his elderly mother. I would ask that the court place him on a term of probation. The recommendation is for 6 months probation. The recommendation is also for Zoom reporting to probation. I would ask the court follow that for a couple of reasons. One, my understanding in speaking with Mr. Darling is that he believes that he'll be able to pay off the restitution within a 6-month period. I don't anticipate that being any issues. Additionally, because of Mr. Darling and some health issues he has, is caring for his elderly mother, and the significant drive, I would ask that he be allowed to report to probation via Zoom. Judge, quite frankly, Mr. Darling has limited criminal history. I think he is taking responsibility for this. Just as a way of background, Your Honor, the issue in this case was that Mr. Darling had taken on some work with these two individuals. He had contracted to do some work. He received payment, and then the work did not get completed in timely fashion. Ultimately, he was charged. Mr. Darling has accepted responsibility for that. The only reason that there was some discrepancy with regard to Mr. Pettit is that there was some work performed at that house. I realize that Mr. Pettit has a different view as to whether that work is up to snuff, so to speak. But nonetheless, the parties have mutually agreed to that 2,000. I certainly think that Mr. Darling is going to complete probation with flying colors. He's never failed to appear. He's not a risk to the community by any means. I think if the court follows that recommendation, Mr. Darling will be all set within 6 months.
Okay, did your client want to make any statements at all?
Mr. Darling, would you like to make any statement regarding your sentencing?
No, Your Honor. I'm pretty good with what the attorney has said.
Okay, thank you. I've had an opportunity to review the pre-sentence report and recommendation as well as prior criminal history. I think you and I might have different definitions of limited.
Understood, Judge.
But there are multiple convictions and at least one other with a conviction of some false pretenses at least. Nonetheless, I think that the recommendation as written is appropriate. And I think that the defendant would benefit from participating in some economic crime programming and some community service. So the court will adopt the recommendation. The sentence will be as follows. 6 months probation will be ordered. There's a $30 per month oversight fee that you're responsible for while you're on probation. Okay, Mr. Darling?
Yes, Your Honor.
Okay, while you're on probation, you will be reporting via Zoom. You're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. You're going to be required to submit to random preliminary breath test and/or urinalysis testing while you're on probation. And you're not to use, purchase, or possess alcohol, marijuana, or controlled substance without a valid prescription. Do you understand that?
Yes, Your Honor.
I am going to require you to complete 10 hours of community service. You'll get 90 days to do that. And he was employed full-time doing construction still.
Yes,
Your
yes,
Honor.
Your Honor.
Okay, you'll maintain your employment and you'll provide evidence of that to your probation officer, okay?
Yes, Your Honor.
Do you have any questions about your probation conditions at this time?
No, ma'am.
Okay, as to fines and costs, there's a $75 crime victim rights fee that will be assessed, plus a $50 state minimum cost that will also be assessed. You're going to be assessed restitution, $2,000 payable to Anthony Pettit, and then there's $2,500 that will be due to Linda Oxendale. I'll waive any discretionary fines and costs at this time. Probation will amount to 180. I'm sorry.
Mm.
6 months of probation will amount to $180. It's a total of $2,805, and you will make monthly payments on that, okay?
Yes, Your Honor.
I think it would be a total of 4,800.
I'm sorry. What did I add up? Who's right?
Sorry, Rob. I didn't even catch it. Sorry.
I only put 2,500. I forgot to put the other 2,000. So your total actually is $4,805. I forgot to add the other 2,000 in here.
Okay.
Do you have any questions about your fines, costs, and restitution?
No, ma'am.
I don't have an advice about your probation. You have an advice of rights as to probation. It says you have been sentenced to a term of probation in the 54A District Court. The probation conditions have been individually tailored and are specific to address your assessed risks and needs. Except for domestic violence, criminal sex crime, stalking offenses, or an offense where the defense of guilty but mentally ill was asserted, you may be eligible for early discharge from probation. You have the following rights: You have the right to request early discharge from probation once you've completed half the original probation term ordered by the judge. Your probation officer may, but is not required to, file a notice with the judge once you become eligible for early discharge. The probation officer must send to you and the prosecuting of the notice. The prosecuting attorney has 14 days from receipt of the notice to file written objections to early discharge. You may request an early discharge from probation after meeting the following conditions. A, you have completed all the required probation programming, and B, you have not violated probation in the last 3 months prior to your request. You must send a copy of your request to the probation officer and to the prosecutor. The prosecutor has 14 days from receipt of your request to file any objections. If a hearing is scheduled for your request, you have the right to hire or retain an attorney. You do not have the right to court-appointed counsel to represent you at that hearing. Lastly, you may make your request for early discharge by completing a notice regarding eligibility for early discharge. That form is called the NC 512 form. That's located on the court website, or you can request it from your probation officer. Do you have any questions today?
No, ma'am, Your Honor.
Okay. Any additional matters for the record on this file, counsel?
Nothing on behalf of the people. Thank you, Your Honor.
And nothing from the defense, Your Honor. Thank you.
Thank you. You're all set, Mr. Darling.
Thank you. Have a great day.
Thank you.
Judge, I apologize for my tardy. I had a calendar for 1:30 instead of 1. I apologize.
She's so used to hanging out over the country club.
That's what they're still calling the 54B the short, huh?
Kind of like that.
Okay, we're on the record in the matter of the people of the state of Michigan versus Frank Andrew Stevens, file number 22-03370. Council appearance.
Good afternoon, Judge. May it please the court. My name is Richmond Riggs, P33863. I am an Assistant Attorney General. I appear on behalf of the people of the state of Michigan.
And Your Honor, Luann Lumberman, also for the people of the state of Michigan.
Don Passenger, P39384, 6,000 behind Mr. Riggs, I guess, for the defendant, Mr. Stevens.
John Moodhart, Your Honor, on behalf of defendant Stevens as well.
Okay, today's the date and time that was set for probable cause conference, and this matter was reset. We have one count of uttering and publishing, count 2 of forgery, count 3 of oil and glass false statement. I don't believe that. Well, I think we did reset the exam for the 24th, but we were going to address any necessary resetting of the timeline today. How are we proceeding?
Judge, we've had an opportunity to speak about the discovery requests that counsel have made for the defendant. I have received permission to release some 500 pages of additional discovery. It was transmitted to them today. It's my understanding that they have received it. There's some technical glitch with part of it, but counsel believes you'll be able to correct that. He has asked for recordings and notes. It is my belief that as far as the notes, we do not have any in my possession, but I want to speak to the officer in charge before I state to counsel that we don't have them. There may be a recording that exists, and if it does, I will get it. Long and short, Judge, I don't think a motion is going to be necessary. I think we've reached agreement on everything they have requested, and therefore I don't believe that there is any disagreement about discovery. I have made a discussion with counsel as to the materials that I've released to them, and we are tentatively scheduled for a teleconference for them to go over the materials. And on March 29th, we will meet via teleconference to discuss the materials and possible resolution of the case. If either way, we reach a resolution or we don't, we have looked at our calendars and we have requested of the court if we might have one final probable cause conference on April 28th. It's my understanding the court prefers to do these on Friday, either at 1:30 or whatever time is good for the court. And we will either take a plea or we will
We can
schedule
do
a
it on either a Thursday or a Friday. So if there's a Thursday that works, we do PCCs on Thursdays and Fridays.
Oh, okay. I think
And
we've
it
sort of
doesn't
all
have to be
cleared.
at 1:30. It could be earlier.
Okay.
I'm available either the 27th or 28th. If the 27th worked better for Ms. Lammerman, I would be fine with that.
I'm sorry, I'll be out, so don't, Richmond can handle it, so don't worry about me.
Yeah, so I'm okay 27th or 28th. I don't know about Mr. Muhart, but so if we just want to stick with the 28th, that would be fine.
I think that's the best.
Okay.
Is there a preferred time for the court on the 28th, if you're willing, Your Honor?
Oh, I have a state bar commissioner meeting on the 28th.
Ah.
27. Sorry? Can you do 1 PM on the 27th?
Yes for passenger.
Yes, for Moodhart.
Yes, for Riggs.
Okay, well then we'll see you on April 27th at 1 PM via Zoom.
All right. Thank you,
Any
Judge.
additional matters for the record today?
Nothing
I
on
don't
behalf of the
believe,
people, Judge.
I don't believe so. I think we've simply indicated that fingerprints will continue until we actually do a probable cause exam, at which point Mr. Stevens will be present in the state. So I think we're good.
Sounds good. I have that noted here in the file.
Thank you so much.
Thank you, Your Honor.
Thank you. You're all set.
Thank you, Your
All right.
Honor.
I sent that to you.